So Alan, you bring
this is going to be a fascinating case that will remind many people of what happened 30 years ago.
You bring up an interesting point, and that's who's going to take the stand. I can't wait to see the witness list. And one of the things that the defense is probably going to be working with is you have one of the witnesses, one of the victims there that said that she saw him. But then she went back to bed and he left the crime scene. It wasn't even reported until later that next day when they found the dead bodies. Do you expect the defense to go after this witness?
Well, they're going to have to be very gentle, obviously. And yet, of course, they're going to have to go after the witness. You have to go after every witness that inculpates a defendant, but you have to go after him in a way that doesn't create a sympathy. Remember, too, that the judge has put the family in the front row of the courthouse, the courtroom, and the jury is going to be looking at the family and looking at the other people and trying to sense their reaction as well. And so the defense has to be very careful as to how they treat witnesses and not put them in a situation where there's sympathy, overt sympathy, more sympathy than necessary to these witnesses. So this is far from a slam dunk. You know, cases look like they're easy when the prosecution presents its evidence. And here we've had a media flow of evidence through programs and other kinds of things. And that's going to be another issue. The defense is challenging leaks. Remember, the judge issued an order saying, no, we can't allow any of this to go on television, and it's gone on television. And there will be hearings to determine.
It's already out there, though. I got about 30 seconds, though, Alan. One of the other things that I'm sure that the prosecution is going to bring up, that the defense is going to have to respond to, is that he was a student. He was a criminology student. Part of that access gave him access to the crime lab. He's researched cases, and so he was methodical in some case. How do you expect the defense to respond to that?
Well, I think they hope and pray that's the strongest evidence, because that's really circumstantial evidence. If you went after everybody who was a criminology student and who had access to this information, there'd be a lot of innocent people. So that becomes one part of a larger circumstantial case. And they're not going to be able to challenge that. They're going to have to adapt that and say, look, he was somebody who was a criminology student. He was trying to help people. He's not the kind of person who would use his criminology background to hurt innocent people.
All right. We appreciate you, Professor Lee.
So that was Alan Dershowitz. You know, we all know him as a TV commentator, but he was also a Harvard law professor. So he's got the credentials. He's got some very famous clients in his past resume. But one of the things he said, which I can totally, and they're throwing it out there right now, I can totally not see is Brian Kohberger ever taking the stand in this case. I think, first of all, if he took the stand, the prosecution would rip him to shreds, you know, in some of his conduct. You know, just the whole story of him, he likes to take rides at 4 o'clock in the morning by himself, sightseeing, looking at stars and all of that stuff. That's, to me, not all that believable. And if he's put on the stand and questioned about that, I think he'll fumble. He'll really seriously fumble. So what will some of the things we're waiting for now, of course, is this continuance. What will happen with this continuance? You know, in a hearing on April 9th, Kohberger's lead attorney, Ann Taylor, told the court she had found the lead on another suspect buried among a trove of tips collected by the police. So that's in regards to the other, the alternate suspect. She also revealed the defense's plan to argue Kohberger was framed by someone planting his DNA at the crime scene, and that 2 people must have committed the crime using 2 weapons. You know, Judge Hippler gave the defense a deadline of May 23rd to hand over evidence to support the claims. According to Judge Hippler, he said, provide me with whatever actual evidence you have that supports those allegations other than just allegations, he said in a hearing on May 15th. And 2, provide me how it is you believe that what you're offering is admissible. it seemed to me much of what you had put in there was potentially fairly objectionable in terms of admissibility. So I would like to see that. Court records show the documents were filed by May 23rd, with the judge granting the defense's motion to keep them under seal. Now the prosecution has until June 6th to respond to claims before a court hearing is held later that month, where the judge will decide if the defense can present this alternate suspect at the trial. And experts tell the Daily Mail, this is their report, that the theory could have a significant impact on the trial if jurors hear it. Ultimately, the jury has to be unanimous. If you convince just one juror that there is a reasonable alternate suspect, he walks, criminal defense attorney David Seltzer said. So it all depends on, will Judge Hippler allow unvetted information that, could it be just invented by the defense? What evidence? Let's use that word. Evidence. What makes other things apparent? Evidence, right? What evidence do you have, Ann Taylor, that makes me want to allow this alternate suspect theory you have? Right now, it's just a theory because we haven't seen any of the evidence. Why should I allow this? Why is it admissible? The judge may rule right out of the box, right at Jump Street. Wait a minute. This evidence is not admissible. It's not admissible at all. So these are all the things that we're waiting for Judge Hippler to rule upon. And in the next few months, there's going to be a whirlwind of activity in regards to this case and rulings on this case. And it's going to be quite interesting.